The Center for Educational Media and the College of Education at Middle Tennessee State University are proud to offer professional development to K-12 educators in Tennessee through our online video library. These videos are aligned with standards set by the Tennessee Department of Education. For more professional development videos, check out our website at www.mtsu.edu/CEM.
And now we're going to turn it over to Ms. Elizabeth Taylor, who is the legal counsel for Murfreesboro City Schools. I've had the pleasure of knowing her for this past year, helping us with my students and speaking as a guest speaker. So she is going to have some great information on ethics, advocacy, and the law pertaining to school counselors. So I'm turning it over to Ms. Elizabeth.
Thank you, Ms. Wilson. As Ms. Wilson said, my name is Elizabeth Taylor. Yes, that's my real name. Insert joke about perfume, jewelry, marriages, Michael Jackson here, I'll wait. Now that we've got that out of the way, I clearly am not an actress or a movie star. I am an attorney. Don't throw tomatoes. But as she said, I represent Murfreesboro City Schools, and my representation at Murfreesboro City Schools really was the inspiration behind my presentation today. In that role, I've had the opportunity to talk to several school counselors and give them advice and train them. Some of them are here today. Hey, Murfreesboro City Schools people. And through those interactions, I learned that when fulfilling the role as a school counselor, oftentimes there are questions about what to do regarding the law, especially when the law seemingly conflicts with what you'd prefer to do as an advocate and what your ethical obligations are. So I thought today that we could take a look primarily through a legal lens, because that's what I do. So I will be calling on you all as school counselors. How many people in here are school counselors? Everybody? School counselors, educators, people who work for the school system, because I'm not an educator and I'm not a counselor. So this is going to be a conversation between all three entities, school counselors, people who work for the school system, and legal counsel for a school system, to see how these areas intersect. And when I say the intersection of advocacy, ethics, and the law, this is kind of what I'm talking about. When I think about advocacy, at its basic level, it means you're a helper. You want to help someone. And as a school counselor, you want to help the students that you support to get out of the circumstances that are causing the issues. And also you can help support them by providing resources, both internal and external. Ethics, that's just the standard rules of what's considered right and wrong. I know as counselors, you have the organizations, the American School Counselor Association, Tennessee has school counselor standards, the American Council Association has standards as well. Just like me as a lawyer, I have certain ethical obligations that I have to operate in my practice. So that's what I mean when we're talking about ethics. And finally, the law. The laws are the sets of rules and guidelines that people must adhere to and that govern the way we act. And if we don't act accordingly, we can be subject to punishment, whether it be fines, jail time, which nobody wants, and things like that. So that's the frame that we're going to be looking at: advocacy, ethics, and the law today. And as we go through the presentation today, it's going to be focused on three areas that I call high stakes areas. The reason why I call these high stakes areas is just because in my service as a school attorney, in my conversations with school counselors, not only in my district, but in other districts, I have family and friends who are also school counselors. These are the areas that frequently come up as questions where they're not sure how their role should be fulfilled when you consider what the law says, what their ethical standards are, and what they feel is best for students as an advocate. So those areas are privacy laws, and that pertains to what information you're able to tell about students that you counsel or that you interact with in the school building. The second is reporting laws. There are several laws that require reporting of student conduct in certain instances. And then finally, transgender and non-gender conforming students, which is under the bigger LGBTQ+ scope, but specifically these are the questions that I get most, is about gender non-conforming students, so we're going to focus on that today. The intersection. When I say the intersection, sometimes in a perfect world, what you want to do as an advocate, what you're ethically bound to do, and what the law says to do align, and that's fine. But oftentimes there's intersections. Ethics and advocacy might be on the same page, but the law says that you have to do something different. Law and ethics are often aligned because laws are typically based on ethics. So those are usually closely aligned, but they might not align with what you want to do as an advocate or what you feel is in the best interest of the student. And so we're just going to take a look through different scenarios and different fact patterns on how we would navigate the differences between what you'd like to do as an advocate or what you think is in the best interest versus what ethical considerations you have to follow, and then what legal implications might result from your action. So the first area, again, is going to be surrounding student confidentiality and reporting, and the counselor's duties and responsibilities in that regard. So first, again, we're going to tackle privacy laws. Anybody that works in the school space knows about FERPA. FERPA is the Family Education Rights and Privacy Act, which governs the confidentiality of student records. It protects the privacy of student records, and it makes it so they can't be disclosed without private parental consent. It also gives parents the control over their students' records. They have the ability to inspect and view student records and also make corrections to them. So if they review a record and they see that something's not correct, then they can petition the school to change it to make it to what they feel like it should be. Again, and it protects privacy by prohibiting the disclosure of personally identifiable information. This is just a refresher. I know anybody that works in the school space has heard FERPA extensively. But from what I have seen in my practice is that what gets people caught up the most, or what causes the most questions, is what is an education record? What is governed by FERPA and what isn't? So an education record is a record that's directly related to the student, that is maintained by the education agency. And in the scope of counselors' work, this is really important because I know oftentimes school counselors might take notes, personal notes, and you're in your sole possession. And records that are in the sole possession of the maker are not considered student records. They're not considered educational records under FERPA. Those are sole possession documents that don't apply to FERPA, or FERPA does not apply to. However, as a cautionary tale, if those records get attached to an IEP, if they get attached to a discipline report, if they get attached to some kind of behavior analysis or a behavior report, and people outside of yourself see them, now they have the possibility of becoming an educational record because they're not in your sole possession anymore. So that's a point that I like to make when I'm talking to people like counselors who might have their own personal records. Be sure that you keep them in your sole possession unless you want to run the risk of having them being subject to FERPA and being inspected by parents and possibly outside agencies, which I'll talk about in a minute. Directory information is not included in FERPA. Each school district should have a policy of what they consider directory information. This is Murfreesboro City Schools policy. It comes right from the federal law. Typically, it's stuff that's not considered invasive if it's released. The student's name, address, telephone number, email address, photographs, date and place of birth, dates of attendance, and dates of attendance is not the attendance record, to be clear. It's just, yes, this student attended from August 2019 to May 2022, that type of record. Grade level, enrollment status, participation in sports and athletics, weight and height of members of athletic teams, honors and awards received, and the most recent education agency or institution attended. That's just the prior school. Of course, we get cumulative records and things like that. And then when high school students have to go on to college, we have to be able to release that information. So directory information is able to be released without parental consent. So if you ever get a request for any of the information that your school district deems as directory information, you can release it without parental consent. So in addition to directory information, FERPA has several exceptions that apply where the school district or the school can release the information without parental consent. So as relative to the role as school counselors, the question that I get the most concerns the health and safety exception, where it says that you can release the information to appropriate officials in a health or safety emergency. To release the information, there's certain criteria that have to be met. It has to be a specific imminent threat that's able to be carried out. Okay, so if a student just gives a general threat like, I'm gonna kill her, like if they're playing a football game or something and they get upset that they, missed a touchdown and they say, I'm gonna kill somebody because they're upset that they lost the game. That's not really a specific threat. They haven't threatened a particular person. In that moment, they're probably not likely to carry it out unless they have a weapon on them or something like that. So that's the types of things that you want to look out for if you hear these types of words. It has to be an actual threat, and it has to be capable of being done. So if a person says that, I'm going to get an army tank and run it through the school because I'm mad that I failed my test, that's not likely to be able to be carried out, right? So that wouldn't fall into the health and safety exception. It's important to note that if something does fall into this, it's not absolute. It's limited to the time of the emergency and the scope of the information that's needed in order to prevent the emergency from happening. Okay, so if somebody is in a real health or safety emergency and the only information needed is what medications is the child taking, because we need to make sure that the paramedics know. We don't have to give them the attendance record. We don't have to give them the full IEP. We don't have to give them all the disciplinary records for that student. We just give the information that's critical in that moment to prevent the risk. So now we're going to look at our first scenario and put the things we've talked about into action. So the police are investigating a fight that happened between two students last week at a local park. One of the students has been seeing you because the parent had concerns about some anger issues the child had began to exhibit last month. The officer comes to your office and wants copies of the student file. What would you do? So at your tables between each other, talk about it, and I want you to think of, number one, as an advocate, what would you do? Ethically, what do you think you should do? And then legally, what do you think you should do? All right, does anyone want to share what they talked about?
So we talked back here, we said absolutely not. So we all kind of agreed that we would send the police officers to either admin or the SRO.
Always a good move. Sending the police officer to the admin or the SRO, but they would not release the records. Anyone else? Or anyone else have a different reasoning?
It's not necessarily a different reasoning, but initially we were thinking that the officer was the SRO perhaps. And in that case, the platform that we use, Skyward, the officer would be able to go in and look at any disciplinary actions that have been taken place, which would, to us, might have been the only thing he really needed, not necessarily the student's academic records that would be in a cumulative file.
That's a good point. And that's a good distinguishing factor. I'm glad you brought that up. She said that if the officer were her SRO, the SRO could go into Skyward, which is their file management system, and look at the student's records. Now, under FERPA, SROs are only allowed to do that if they are a school official, so if they work for the school system. or they have a certain relationship with the schools. And the school district that I represent, SROs would not be allowed to do that. We do not allow them access into our file system. They're employees of the Murfreesboro Police Department. We have an MOU with them that lays out their rights and responsibilities and what they do, and that would not be included in that. So our SROs would not be able to do that. But thank you for bringing that up, because that's a good point. Of course, I think it's pretty clear that this wasn't an imminent threat or emergency. The fight happened 2 weeks ago, last week, and it didn't even happen at the school. But when I was thinking about this, the advocacy standpoint is, of course, you want to protect the students. Me as an attorney, I try to keep children out of the juvenile justice system. I don't do criminal law or anything, but I don't advocate for putting children unnecessarily in the juvenile justice system. So in my mind as an advocate, I would want to say, wait, police officer, are you going to press charges against the student? Why do you want this information for a playground fight? Also, at the same time, we have close relationships. If it's the SRO at your school, you might want to say, well, I want to help be an advocate to law enforcement and help them do their job and make sure that no student is in danger, whether it be the student that they're asking about or maybe this other student that got into the fight, and maybe there's some continuing neighborhood beef going on and you feel like maybe I need to help do something to prevent that. So that's kind of the thoughts that I had regarding the advocacy aspect. As far as ethical, of course, you have the ethical duty to protect your students' privacy and not unnecessarily disclose information. Also confidentiality, keeping what you and the student discuss private between you two. And then finally, privilege. Privilege basically means when a mental health professional and their clients don't have to disclose information. And the reasoning behind that is because they want to foster that open trust and open communication between providers and clients. So the privilege is more of a legal type situation where you wouldn't have to be compelled to testify and things like that. So I think you guys got it exactly right. I would advise any of my school counselors not to disclose the records, or any employee at that. So aside from FERPA privacy laws, we also have reporting threats of serious bodily harm or death. And for the past 2 years, this has been something that I have tried to preach, and I've gotten so many questions about, and I don't know how many of you guys are familiar with this Tennessee law, but this is the text of the law. As you can see, there's a lot of words here. When you have a lot of words, for people who aren't necessarily lawyers, it can get confusing and you can get a lot of questions about it. But at its core, what this law says is that if the student is a service recipient, and if you are a qualified mental health professional or behavior analyst, and there's an actual threat of serious bodily harm or death that's capable of being carried out, then you have a duty to report it to law enforcement. And the law enforcement will take action. So within this is a couple of definitions that I want to go over, because it may not apply to every situation, and it likely doesn't apply to a lot of situations. So the student must be a service recipient, and the law defines a service recipient as a person who's receiving a service, has applied for a service, or for whom someone has applied for a proposed service because of mental illness, serious emotional disturbance, or developmental disability. Okay, so if you have a student that has made a threat of serious bodily harm and they don't fall into this, then you do not have a duty to report it to law enforcement. And that has been the conversation that we have had in our district, because some law enforcement believes that any threat of serious bodily harm, specifically and the threats of suicide, needs to be reported. So we have done a lot of conversations about that. I've gotten a lot of questions about that, where the law enforcement officers are saying, you guys should have reported this to us, you had a duty. But unless the student was a service recipient and you were a qualified mental health professional, which the law outlines here, you do not have a duty to report. And the law defines a qualified mental health professional as a person who is licensed in the state if required for the profession and is a psychiatrist or a physician with psychiatry as determined by training, education, and experience, a psychologist with a health service provider designation, a psychological examiner or senior psychological examiner, a licensed master social worker with 2 years of mental health experience or a licensed clinical social worker, a marital and family therapist, nurse with a master's degree in nursing who functions as a psychiatric nurse, a professional counselor, or if the person is providing a service to service recipients who are children, any of the above education credentials plus mental health experience with children. Based on that definition, does anyone in here qualify as a qualified mental health? So if the student was a service recipient, then you would have a duty to report. If not, you wouldn't have a duty to report. So those two things have to be met, and then in addition to the threat, before there is a duty to report. So that's important because we want to make sure that we're just not giving carte blanche information to law enforcement, and again, making things a law enforcement issue when they don't need to be. And those three that I have underlined, those are the ones that I thought might be most applicable to someone in a school setting. So again, this is the simple reporting checklist for the Tennessee law. Is the student a service recipient? Are you a qualified mental health professional behavior analyst? Is the threat an actual threat of serious bodily harm? And remember what we talked about with FERPA when we talked about actual impending emergency situations. And is the student capable of carrying out the law? If all of these are met, then you have a duty to report it to law enforcement. And this is what you have to report when you make the report, just the name of the service recipient, which would be the student, the name of the mental health professional or behavior analyst, and the name of where the student is being treated, the date of birth of the recipient, the race and sex, and the social security number if you have it. So the law also outlines what information we have to give. Again, we want to stay within the lines of what we have to give and not give extraneous information that we don't need to. And then, of course, I'm sure you guys are all familiar with the threat assessment laws in Tennessee. And you guys members of your school's threat assessment team? So under the law, school districts have to have threat assessment teams that respond in the event that a student presents a risk of harm to themselves or others. And again, under that law, we can disclose information contained in the record in the event of such an emergency. And again, we still have to keep in mind the FERPA considerations, the Data Accessibility, Transparency and Accountability Act, and all other relevant privacy laws when we're making these reports. So here's another scenario to talk about. The student is referred to you by a teacher after she wrote a poem for a class about not wanting to be here anymore. According to the teacher, the student appeared to be withdrawn and despondent. You speak with the student, who advises you that her parents are going through a divorce and her father just moved to another city. She also got into an argument with her boyfriend because he gave her an STI. She explained her poem meant that she wanted to move to the other city with her father, and she did not want to be in school because her boyfriend was there. She assures you that she is fine and she has been working through her feelings with a therapist. What would you do? So again, talk to your neighbors. What would you do as an advocate? Are there any ethical considerations that you need to take into account, and any legal implications if you act a certain way? Okay, who wants to share what they talked about?
I started using the Ask You suicide screening tool that was recommended to me by our new district supervisor. And so it asked the questions we would ask anyway, like, have you ever wished you were dead? Do you feel like you'd be better off if you were dead? Those kinds of things that kind of assess what's really going on. It asks if they have a plan or if they've ever attempted anything. And essentially the tool says, if they answer yes, that's a flag. And then you ask, if they have thoughts right now, to assess their acuity. But essentially my philosophy is if they say yes to any of those, they're at risk to themselves, and that's when I call mobile crisis and let them make the final decision on their lethality or the burden of that. And that really helps.
And did you find any ethical concerns or ethical questions? Particularly, I know she mentioned that she had a STI. As far as pursue, like to tell parents or anything like that?
Do you want me to answer that?
Yeah. I was just wondering, and I'm asking, and I asked the question. I don't know the answer because, again, like I said, I'm an attorney. I'm not a school counselor. So I just wondered, like, when you go through these things, like, what are the ethical considerations? And then, as an advocate, wanting to make sure that her health is protected, how do you thread that needle?
I gotcha. So I'm actually an elementary counselor, so my students usually don't come, but I have an answer. Because if they come to me, right, I'm calling the police because it's straight up illegal. But it would really kind of depend on the kid's age. Are they of age of consent to even be doing this kind of stuff? But also a lot of like health centers, pregnancy health centers, that kind of stuff will offer some services to kids, I want to say like over 16 without parental consent, and that kind of depends on the situation. So I was more focused on the suicide aspect, but yeah, if they come to me in elementary, that's going to the police.
It also mentions that they're working with a therapist, so I would get a signed release to be able to communicate and make sure that we have that, in the event that they're working on skills, or we can use similar language. I'm also elementary, we don't have SDIs and things like that, but anytime we have a student working with someone outside of school, we really want to bridge that and those connections and make sure that we're supporting that student.
Right, and that's an excellent point that they brought up about the age of the student. That is a really big factor when we talk about things like this, especially when it's something with sex and STI. And that's something that I hadn't even thought of when I wrote this, was how the different age groups there'll be a different response, because with the STI, like she mentioned, she'd call the police, and you'd probably call DCS, right? Because we're mandated reporters, and that would probably be signs of a child being abused. So that was a good point that I hadn't even thought of. Thank you for that. I think there was a hand in the back of the room as well.
I'm a high school counselor, so it's something that we get fairly often. I always ask them if they want to go see the nurse or have the nurse come into our conversation so she can explain some of the ramifications and if they've gotten checked or not. And then obviously if the sex was consensual or if the boyfriend forced, things like that, to just make sure, and then offer them information about free clinics.
All very good steps. Do you think this rises to the level of a report that needs to be made for threat assessment or the Tennessee reporting law? Right, I don't think so either. I can see and I appreciate the teacher for referring the student to you based on how the poem that the student wrote and the student being despondent and sad, just so you can do the assessment to determine whether or not there is an actual risk here. But I think it wouldn't rise to the level of immediately reporting. What about this? The student has been posting pictures with guns online, along with captions stating that he will get revenge and everyone will pay. It is reported to the school by several students, and the principal asks you to speak with the student. The student discloses that he has been diagnosed with a conduct disorder and is seeking treatment by a psychiatrist. He says that he is tired of being bullied at school, and if it does not stop, he cannot be responsible for the harm that he will do to his tormentors. What do you do? So what would you do? Who wants to share?
So we talked about we would admin and SRO and possibly a threat assessment. That's what we talked about back here.
So they would talk to their admin and their SRO and possibly do a threat assessment. Anyone disagree or agree? Or anyone would do anything different?
I'd also get the parent involved, and I think pretty much the same.
Okay, so yeah, this one presents a lot of different issues, right? So we have the threat of the student posting, well, the student posting pictures online with guns and making threats. From this, it's not clear what's included here is general, but what if he made a specific threat against a specific person in the school, right? Then it becomes a school issue, a possibly bullying issue, and he's saying that he's being bullied, so there needs to be a bullying investigation into his claims as well. Even though he's making these more severe claims about shooting people, he has also put the school on notice that he's being bullied. So the admin would have to get involved and do a bullying investigation into that, and then also investigate his posting online to see if it violates any school rules. As far as him making threats that he's tired of being bullied at school and it doesn't stop, remember under Tennessee law, we have to meet those certain thresholds in order to report it to a law enforcement officer. So it says that he has a conduct disorder. So is he a service recipient? Yes, he's under the care of a psychiatrist who is a qualified mental health expert. Are you a qualified mental health expert that he's reporting it to? It depends. If you are, then you would have a duty to report. But also something here to consider is the threat that he made. The threat that he made is he cannot be responsible for the harm that he'll do to his tormentors if the bullying doesn't stop. And remember when we talked about threats that they have to be actual and imminent. Would you guys consider that an actual and imminent threat? Some people are shaking their head yes, some people are saying I don't know, and I would say I don't know. Legally, I think it could qualify as a conditional threat because he's saying that I'm only going to do this if something else happens. If he's no longer bullied, then the threat doesn't exist. However, given that the climate that we're in with school shootings, that's not a risk that I'm going to take. It's splitting hairs between a conditional threat and an actual threat. Someone threatens something like this of this magnitude, and combined with the pictures that he's posting, we're going to treat it as an actual threat. Get the parents involved, get admin involved, and get law enforcement involved. So I think you guys are all 100% right. And these are the kind of considerations when reading through those two scenarios that came into my head: protecting the students, protecting the others, collaborating with stakeholders as an advocate, getting outside help, and talking to parents. Do you have a question?
Is there ever a chance that students innocently talk the language and don't realize the repercussions of what they say?
100%.
And is it worth thinking about training and being very, very specific with students? If you say things like this, these are the consequences that will happen. And we just want you to know that and not let you figure it out on your own. Is that worth talking about?
That's actually something that we have a conversation with our teachers about. The not wanting to be here, the suicidal comments, and the I'm going to kill somebody, even if it doesn't, it's not an actual threat. We want to encourage the kids to have, better verbal skills and use different words so that they don't inadvertently get themselves in trouble. So that is a conversation that we as counselors will a lot of times have with the faculty as a whole, saying, even if you don't think it's a real threat, you still need to report it to us so that we can work with those students on better coping skills.
What you just said is exactly the same procedure that we would follow. We would follow our suicide screener processes or our threat assessment processes, the supports that we would provide after the fact for the students and to the parents. Definitely would address the language, but then also we have protocols for situations where we have students that might be, for lack of a better word, repeat offenders for utilizing, that kind of expressive language that throws up the red flags. This is very important with our students with developmental delays or in our low incidence classrooms, because they oftentimes aren't able to understand the impact of the language that they use.
Yeah, and I think that's absolutely right, because I'm coming from the legal side. If I find out that a student has said something that might have warranted a threat assessment, or warranted reporting, I'm going to say, hey, why didn't you do this? Because it's a liability, right? If something does happen, then it's going to say, well, the school should have done X, Y, and Z because the student said this. So to the extent that we can mitigate that, I think it's a good thing. So,
and it doesn't need to be put in an email. It needs to be said directly to an administrator or the counselor, and if you can't find one or the other, you need to find somebody, and that child doesn't need to be left alone unsupervised.
Now you're speaking my language, right? Don't put anything in writing. That has nothing to do with the presentation that I'm giving today, but if your school attorney has not told you this before, do not put anything in writing that you don't want as a headline on the local paper or flashed across the local news, because if you are communicating regarding school in your official capacity as a teacher, counselor, admin, those could be subject to the Open Records Act, and someone could discover those emails and publicize them. So that's a little side note. Thank you for bringing that up. That's just also that's not a conversation to have via email, right? You need to talk to somebody about it. So that's an excellent point. Okay, the next area that I get a lot of questions about are transgender and gender nonconforming students. And this really is on the legal side of it is a Title IX issue. And Title IX prohibits discrimination on the basis of sex. And the enforcement of this is done by the U.S. Department of Education's Office of Civil Rights. And enforcement of this from presidential administration to presidential administration has changed, but currently the U.S. Office of Civil Rights does enforce and investigate violations of Title IX on the basis of sex regarding sexual orientation and gender identity. You guys just had a presentation on this, so we're not going to go through all of these definitions and what they mean. I'm sure you guys operate in the mental health space. You're well aware. But when we talk about it in the school aspect and how we respond to students, I think the last two are particularly helpful, is the preferred gender pronouns, because not everybody will want to be called the same pronoun. They might choose different pronouns. They might and that's outside of he and she. There's lots of other different ones that people prefer to use. So that's important to consider when we're having these conversations. And then also the transition process. It's not linear. People transition in different ways. Some people transition socially first, and then they might bring it to the school building. Some people might present one way at school, and then maybe at home, because of their family situation, might not present the same way. Some people might wait until they're fully medically transitioned to present. So it looks different from person to person, and that's something to keep in mind as we navigate these issues. So the question that I always get is, a student has told me that they're transgender or gender nonconforming. What am I supposed to do? How am I supposed to react? What do I tell the parents? Do I not tell the parents? Do I tell other teachers? So it's a touchy subject. It's not quite as foreign as it used to be. It's becoming more prevalent even in the lower grades, because again, my district is pre-K through 6, and there was a time when I thought it would never be an issue, but it's coming an increasing issue now that needs to be addressed and deserves to be addressed. So the first step is to relax. You are not alone in having to face this issue. You have a room full of people here that you can collaborate with, as you're doing today, that you can consult with, and that you can talk to figure out how to do it. So don't feel like you're facing this alone. There are resources and people available to help guide you through it. And even just here today, and the hour and a half that I've been in this building, I've heard so many great ideas and so many great approaches to this issue. So that's the first step, is just to relax. The next step is talk to the student. Sometimes you might find that the student is just telling you because it's weighing on them. They're not ready to do anything about it just yet. They just need a trusted adult to talk to. So talk to the student and figure out, what do they want to do? Are you telling me this because you want to change how you present in the school day, change which bathroom you use, change the name that you use in the school building? Or again, are you just looking for someone to talk to about it? Okay, and then once you talk to the student, you know, you might have to bring the parent in depending on what the student wants, and especially with the younger kids. There was a time in a previous life that I did civil rights work for the Tennessee Department of Education, and I was tasked with Title IX work. And at that time, like, I was staunch, like, it's the parent's right, it's the student's right, it's the student's right, a parent can't take that away. It is the student's right, but I've realized as I've represented a school district, it's not that black and white, especially again with the younger kids, where the parents have control over the school records and what names go on that record. The parents pick what clothes the students wear. If you go to a parent-teacher conference and the student says they want to be called one name, but the parent says, no, we're not accepting that, we're going by this name, what name do you use at the parent-teacher conference? Like, those are the types of things that are going to come up, and I think it's essential, to the extent possible, to get the parent on the team to figure out what it's going to look like during the school day, to get a plan in place. And so I would say the first step is to create an administrative support team. I hope the school counselors would be on that team. I think you guys are the champions of mental health in your school building. You are the champions of a safe, supportive, and inclusive school culture. So it's very important. I would hope that your administrators would get you involved in any transgender student issues. Also, you would probably need a principal or an AP that can help with, with any accommodations that might be made, possibly a school nurse if there's medical issues involved and things like that. Agree on a plan to reflect the individual needs of the student and how the student's change is going to be initiated into the school building. You want to have a solid plan of, like, how will other teachers be notified? Who's going to notify other teachers? How are you going to notify other students? It's important to speak with the student and their parent, because again, we're dealing with privacy issues here. We don't want to out the student. Like, it's not our job to out the student if the student tells us that they're transgender. It's our job to work with them, support them, and create a plan so that they're able to fully participate in the school day and be successful. And then under Title IX, we can't discriminate. And so we want to make sure when it comes to things like the bathroom, locker rooms, field trip, dress code, which I heard you guys all talking about during the last presentation, and grouping students by sex, the graduation dress codes, that we're not discriminating based on a student's gender preference. So again, where do school counselors fit in? A member of the support team assists students by being their counselor, by being their trusted advocate, also by being a resource both inside the building and providing resources outside the building. I think I heard some of you guys talk about resources that you give to parents in different regards, so definitely that's something that's needed because it carries on into the family life and they're going to need support outside of the school hours as well. And then serve as a point of contact. I heard some great ideas about how you guys incorporate things into your classroom and to show that you're inclusive and that you're welcoming of all people during the last presentation. So I was really pleased to hear that and how that's being carried out in different schools. So again, maintaining rights to privacy, that's a big question that I get is, do I have to tell the parent? A student comes to me and tells me that they're a lesbian, they're bisexual, they're transgender, whatever. Do I have a duty to tell the parent? And my answer to that is no. You don't have to tell the parent. The only time I would say is to get the parent involved if the child is wanting some change to the school day, like they want to use like a different bathroom, a different name, and things like that. And then of course you want to talk to the student before you get the parent involved to let them know. You don't want to do it behind the student's back. You want to make sure it's an inclusive conversation. You don't tell every teacher in the building. Again, that's a conversation that you have with the team to figure out how this is going to be presented to the school. You don't send letters home to parents without the student's permission. In my research on this subject, I have found where, not in Tennessee or anywhere, but there are parents who have said, I am okay with you sending a letter to the class that says my child will now be referred to as this name. And the parents are okay with it, but we don't want to do anything like that without the parents' consent, right? Because it's a privacy issue. So here's another scenario. Sarah, a student in your school, told you about one of the teachers who goes out of her way to address Sarah as Robert, the name assigned to her at birth. Despite Sarah's request otherwise, the teacher refers to her as Robert and uses male pronouns when referring to her. Sarah is upset about it and wants the behavior to change, but she also does not want to make a formal complaint and wants to remain anonymous to avoid retaliation. How do you respond? What are your next steps? And what are the pros and cons of each? Who wants to share?
And we did talk about a couple different things about encouraging the students, since they did want to remain anonymous, maybe just trying to encourage them to have a conversation with the teacher. But then also we talked about, being very observant, and maybe we could actually witness the teacher maybe in the hallway calling the student by the non-preferred name, and then that would give us an in to kind of talk and everything.
We talked about how, because the teacher is a peer from the counselor, that we would probably be getting admin involved and just saying, this is detrimental to the student, and we need to either address it as a whole for the school, or, maybe we even talked about, are the parents aware? And if the parents are aware, can they come in and help us advocate on behalf of the student, so that no further damage is done?
I actually had this situation happen before, and I went to admin to ask how I should respond, and we were advised that we needed to have parental consent to call the student by their preferred name, and so I reached out to this particular father, and he felt like the child was just going through a phase, and he wanted us to call her by her given name and not the name that she wanted to be called. And so her peers called her what she wanted, but the teachers were told not to do so. So, and then we had some additional questions, like, if this was okay with the parent. Was this bias on the teacher's part that was just being, adamant that he wasn't going to, or she wasn't going to call the student there by the name of choice? We wanted just some additional information.
Yeah, that's a good point. Does anyone else have a rule like that in place where you need parental consent in order to call the student by their preferred name? Let's see, one other person has that. No other people. So reading this in my legal mind, like the first thing that went off to me was like Title IX. This student feels like she's being discriminated against and treated unfairly and improperly because of her gender nonconformity. So again, admin would definitely be involved to determine whether or not we need to do a Title IX investigation, because again, gender nonconformity falls under that. But those are all good aspects, and that just shows how different people, my legal mind sees it one way, you guys as school counselors see it as an advocate, like getting the parent involved, trying to coax the child into, not coax, that sounds like you're coercing, but trying to let the child know, these are the steps that you can do to help advocate for yourself. So this one is a final scenario. A 5th grade student confides that he feels attracted to boys in his class. He wants to tell somebody but isn't sure what to do about his feelings and doesn't think his parents will support him. How do we respond? I think we pretty much covered that through our other conversations today, that it's not our job to out the student. Everything that you guys have previously said would apply as far as being a support, finding out what the student wants and how to proceed. And really from this, he is not sure yet. He just wants someone to talk to. So I think we can all agree on what to do in that situation. So in talking about these issues, these are the types of advocacy, ethics, and legal things that came to my mind: is protecting the students, protecting others if necessary, collaborating with stakeholders, maintaining confidentiality, privacy, and then we also have issues of FERPA when we talk about what we disclose and what we don't disclose. Anti-bullying laws is huge when we're dealing with LGBTQ plus students. Title IX, of course, as I just talked about, and then sometimes HIPAA can be implicated. Not likely in a school setting because most schools are not HIPAA entities, but even if HIPAA doesn't apply, we want to make sure that we keep people's personal medical information private. So now I think that Dr. Clark is going to facilitate Q&A.
So let us begin with questions in the room.
It's not as much of a question because I know it's in law. I'm looking at it right now. But I know that there is some, just some counselors aren't aware that there is a law in place now that we can refer students out to private mental health without the LEA or the school counselor being responsible to pay for that. We aren't required to pay for that. We don't have to fear having to cover the cost when we make a referral. Because I know that it's a little couple years old, but it's still not quite out there for everybody to know.
I did not know that was out there, and I'm a lawyer, so I appreciate that.
There is another question. And this is from live stream. Are threat assessment teams only required in secondary, or does it include all schools pre-K-12?
I believe it includes all schools. We have one, and we're a pre-K through 6 districts, and Murfreesboro City Schools has threat assessment teams, so I believe it includes all schools. But I would have to double check the language of the law to verify. If it's not required, you can go above and beyond what the law requires, and I think it's a good idea to have one even if it's not legally required for pre-K or through 6 or 8th grade middle schools, because it's needed. We've had to convene as a threat assessment team a couple of times in my district, which does not include any middle school or high school. So I don't know if it's definitely included, but I think it's a good idea even if it's not.
And we had another comment from the chat, just a general statement that this person says they like to consider in situations and sometimes ask themselves, in this situation, am I a protective factor or am I a risk factor? The counselor. Am I a protective factor in this situation, or am I a risk?
I'm curious to know what that person means by a risk factor. Like, are they posing a risk to the student, or like a risk to the school system or the school? So to whoever made that comment, what kind of risk do you think you would pose?
And there's no further comment here, but I'd love to hear any thoughts from the room on that.
Do you guys ever feel like you're a risk? I've never heard a school counselor referred to in that regard, so I'm actually intrigued by that statement.
It might come into the discussion about implicit bias. And as counselors are learning and growing, there may be some risk of us not even being aware of our implicit bias. I'm not challenging you in any way. I highly respect the work you do, but it's, it could lie in our implicit biases.
Yeah, and I think we all have them, right? Just like when
Absolutely.
we were going through those scenarios, I'm viewing it through the implicit bias of being a lawyer. Like, I'm looking for legal red flags, things that are gonna get the district or the school or the teacher or whoever in trouble, not necessarily thinking of what's in the best interest of the child. Like, I'm thinking like, what's in the best interest of us not getting sued? So that's my implicit bias that is ingrained into me based on my education and experience.
I think for me, I had a student that got very attached. They wanted the attention. They needed the help. They had a lot of mental health problems. They had been in and out of treatment facilities. So if I wasn't in school, there was always a big blow up. So then she knew I'd hear about it. If I was too busy to talk to her, she'd go to class and say, I'm going to kill myself, because then she knew she'd get to see me. So I feel like in a way I was a risk for her because she had such a bad attachment. Then it made it dangerous for her because she didn't know how to handle her problems.
Wow, that makes sense. And that's something that I never considered. Thank you for sharing
I
that.
also think the suicide prevention, like, at least in my district, I decide, like I do a suicide prevention like questionnaire, but then I decide if they need to go to the hospital, mobile crisis. Like, a lot of it's on us to do. And so I think that's always a risk as well.
Gotcha. Yeah, that makes perfect sense. Thank you.
On one of the slides back, you had said we were talking about informing parents with regards to pronouns and preferred names. And it says in there to include the parents in this discussion. Is there in the law and ethics or in Title IX, is there like an age of consent where we would be allowed to not include the parent in that conversation?
Outside of age 18, where a student is is not considered a minor anymore, that's the only cutoff I could see, or maybe if the student was emancipated. And that's, again, that is really an issue that, especially with my age group of students that I represent, it's hard. And I've reached out to different agencies to try to get some clarity, and nobody really knows what the answer is when it comes to student one in one thing and parent one in the other. How do we thread that needle? So as far, outside of being 18 and the age of majority to control your own education records and your own education, then I would say there is no cutoff.
And we had a response when we were debating what kind of risk, how might we be a risk, and it goes along with what our colleague from Clarksville Montgomery pointed out, and the person on live stream said they were referencing suicide prevention.
Gotcha.
So in a situation where we might misread it or be perhaps a barrier to something happening.
Yeah, and I definitely think that's a fair point. Is there anyone in the building or anyone in the room or on the live stream that runs it by multiple people? Like, do you have to get a second opinion, or if there's more than one school counselor in the building, do you run it by any colleagues? Does anyone do that? I'm just thinking of ways to not make like one person solely responsible for making that decision.
I worked in an elementary school by myself for 10 years, and I didn't have that. And now I'm in a high school with 4 other counselors. Ms. Peterson is one of my counselors. She's right next to me, so she gets to be the lucky one that if she's available. I think that's a personal thing for me, especially working by myself. Not that I don't trust myself, but I like to have just that I process this with another professional who does the same work that I do every day. If that's possible for me to be able to do that, then I do try to. I think it's just, I know what I believe is the right thing, but it's nice to have colleagues that I can step in and say, okay, this is what I'm thinking. I just want to process these, facts really quickly, and get some feedback. But I think that's just a personal thing with me.
I think that's absolutely valuable. Any other questions?
As I was listening to Dr. Gordon during the first session, I looked up if gender dysphoria and gender identity disorder are covered under 504, and they are not, unless there's a physical impairment. And so would we have to address this under Title IX?
Yes, Title IX and 504 are separate. Title 504 is based on a student having a disability. So I guess with those not being included, they're not regarded as a disability under federal law. Title IX addresses discrimination based on sex, and in the interpretation of that, someone's gender identity or sexual orientation is included in that. So that's where the difference lies. 504 is strictly for students with disabilities, and Title IX is it's not even just for students, but it prohibits discrimination based on sex.
I was just thinking of it as, it would be a mental impairment, potentially, because it's physical or mental impairment under 504. But it specifically says that those particular diagnoses are not covered under it unless there's a underlying physical impairment.
Right. And so, again, like 504, that means that they wouldn't get any accommodations to the classroom environment. But again, Title IX would still, we can't discriminate against them. So that means they can't be treated differently on the basis of their sex, whereas what 504 is saying is that we're not including these as a physical or mental impairment that would entitle the student to accommodations, if that makes sense.
Miss Elizabeth Taylor, wow, what a session. So, Ms. Taylor, thank you.
Thank you for having me.
Thank you for bringing this to us today. And now you know a legal resource, right, in our state.
I'm glad you said that, because my disclaimer slide, I am a lawyer, but I am not your lawyer, except for that Murfreesboro City Schools row. If you have questions, you need to reach out to your own legal counsel for your district, and they will guide you on your district's policies, procedures, and interpretations of the law. So thank you for saying that.
Thank you for that clarification.